Going through a family law case, it can be just incredibly overwhelming and honestly pretty confusing. It's this deeply personal, private process that all of a sudden becomes very public, very structured. So, in this explainer, we're going to use our sources to build a clear guide, a map, really, to help you navigate the whole thing and make sense of it all. So, let's dive right in with the big question on so many people's minds. When the negotiations stop and a trial is right around the corner, what actually happens? It can feel like you're stepping into this total unknown, but there is a process, a playbook even, that guides everything. And it all kicks off with one absolutely critical choice. Long before you ever set foot in a courtroom for an actual trial, you're going to face this huge fork in the road. Do you settle the case yourselves, or do you let a judge make the final call? As we're about to see, this is often the single most important decision you'll make in the entire process. And there's this fascinating bit of psychology that comes into play right here. Our sources point out that when a trial is no longer some distant threat, but it's happening, like next week, suddenly, folks who were digging their heels in are a lot more willing to negotiate. That final pretrial conference is often where the sheer gravity of the situation and the loss of control really truly sinks in. And believe me, the stakes could not be higher. A settlement is private. It's a negotiation that you control, and it's almost always less expensive and way less traumatic. A trial, on the other hand, it's public. It's designed to be adversarial, it's costly, and every single word spoken becomes a matter of public record forever. That choice really defines the entire experience. This quote from our source just gets right to the heart of it. The prospect of having a skeleton or two revealed in open court has been known to convince a client. Wow. That fear of your personal life being laid bare for all to see is an incredibly powerful motivator. A trial means losing control of your own story, and for a lot of people, that's just a price that's way too high to pay. And this is such a crucial takeaway, right? Even when a judge's order is signed and the case is legally over, the family's story isn't. Our sources remind us that when you have kids, you're connected for life. Through graduations, weddings, future grandkids, the whole shebang. A good settlement can pave the way for a decent co-parenting relationship, but a nasty trial can leave scars that last for decades. Okay, but what if a case does go to trial, especially one that involves custody? Well, there is one single principle that guides every single decision the judge makes. You should think of it as the North Star of family court. It's a legal concept called parens patriae. It's a Latin term, and it basically means parent of the nation. In family court, it means the court steps in to act as the ultimate protector, the ultimate parent for the children. So the judge's job isn't to take mom's side or dad's side, it's to take the child's side. And look, this requires a huge mental shift. A key insight from our research is that a parent who walks in focused on their own feelings, what they want, what they think is fair, well, that parent is on an almost guaranteed way to lose a child custody case. The entire argument has to be framed around what is genuinely best for the child. Period. And this isn't just the judge going with their gut. The court looks at specific, concrete factors to make this decision. They're going to consider everything from what the parents want to the child's own adjustment at home and school. And this one is critical: which parent is more likely to encourage a healthy relationship with the other parent? It's a really broad fact-based analysis. Okay, so you're heading to trial. It can feel chaotic, but success in court is almost always rooted in meticulous preparation. This is where lawyers develop their playbook, their strategic map for how they're going to navigate the courtroom. And the absolute central tool for all this prep work, as highlighted in our sources, is the trial notebook. Now, this isn't just a random stack of papers. It's a highly organized, tabbed binder that's basically the command setter for the entire case. Everything from key facts to witness outlines is right there at their fingertips. So, let's peek inside this thing. You've got a section for the core facts of the case, then a section for each legal issue and the evidence that proves it. Then there's a detailed plan for every single witness, who they are and what they're going to say. Another one for every piece of evidence. And you even have an outline of the closing argument ready to go. It's this level of organization that lets a lawyer react to whatever surprises pop up in a trial. Now, a huge part of that playbook is deciding who's actually going to testify. Our sources make a big deal about this.
Some lawyers want to show up with a whole busload of witnesses, but that is a massive mistake. Judges have seen it all, and they are not impressed by numbers. They want credible, direct witnesses, not a parade of people with obvious biases.
So who do judges actually find effective? Well, neutral third-party professionals are gold. Think teachers, counselors, or school principals. Their testimony is seen as objective. And who's the least effective? Almost always friends and family. A judge is almost never going to be swayed by someone's mother saying her son is a great guy. The bias is it's just too obvious. This brings us to probably one of the toughest, most emotionally loaded questions in any custody case. Should the children themselves be put on the witness stand? The guidance from our sources on this is crystal clear. You have to proceed with extreme caution. Putting a child on the stand can be really traumatic for them. And on top of that, their testimony is often pretty unreliable. Not because they're trying to lie, but because kids instinctively tell adults what they think that person wants to hear. It is an incredibly high-risk, high-stakes strategy. All right, deep breath. The prep is done. The playbook is set. Now we're actually stepping inside the courtroom. This is game day. This is where all that strategic planning gets put to the ultimate test. A trial follows a really clear sequence. It kicks off with the opening statement. That's kind of like the movie trailer for your case. Then you move into direct examination, where you present your witnesses and your evidence. That's followed by cross-examination, where you get to challenge the other side's case. And it all wraps up with a closing argument, which is your last best chance to persuade the judge. Now, of all those steps, cross-examination is usually the most dramatic and the most dangerous. It's like high-stakes legal chess. And according to our research, it is governed by one single golden rule. And here it is. The biggest mistake you can make is asking a question when you don't already know the answer. See, the point of cross-examination isn't to discover new information. It's to discredit testimony or get a witness to admit a fact that helps you. Asking that one extra unknown question can, and often does, backfire spectacularly. So after all the evidence is in, all the arguments are made, the journey finally arrives at its destination. The case, and really the future, is now completely in the hands of one person. This might be the most important thing to understand about family court. The judge has immense power, what our sources call extraordinarily wide latitude. Unlike other types of law that have these rigid formulas, family court decisions are custom fit to the specific facts of each case. And what that means is that a well-prepared, well-argued case can truly make all the difference. And so we end right back where we started. A trial gives you a legal conclusion, an order from a judge. But as we've seen, it doesn't end the human story. So the final question isn't just a legal one, it's a personal one. How will the path you choose to take and the story you tell in that courtroom shape the next chapter for your family?